it's Tara Lucke here again, and we are back to our regular scheduling and programming of our weekly lives. So today's Facebook Live is going to answer this question that came through from one of the students in the Art of Estate Planning course, which is, what does a super proceeds trust look like in a will? So I want to do a bit of a summary about what a pre-death super proceeds trust looks like. We've done a Facebook Live before about post-death super proceeds trusts and estate proceeds trusts, but we haven't really dived into how to incorporate a super proceeds trust up front in a will as part of the testamentary trust. Now, I am doing this solo again without an assistant, so I'm going to be looking down at my second screen to see about any comments, and so bear with me if I'm looking back and forth, but thank you everyone for joining so far. So, pre-death superannuation proceeds trusts. Let's start at the very beginning. So we all know that when a member dies and they're looking at having their super balance paid out, they are bound by this CIS Act about where that money can go. It can't just go, to their friend or their sibling. It has to go to either the CIS Act dependent, which is basically spouses, children, financial dependents, or it can go to the legal personal representative for distribution under the will or under the intestacy rules. And that will usually depend, that decision on where it goes to the CIS Act dependents or to the legal personal representative will depend on whether there is a binding death benefit nomination or BDBN in place, or if we're relying on trustee discretion. So if it comes into the hands of the legal personal representative, distributed under the will, we then have the option of paying those amounts to a testamentary trust or into a super proceeds trust. So when we're talking about the pre-death super proceeds trust, that's basically just a testamentary trust with a narrower range of beneficiaries. Okay, it's a testamentary trust with a narrower range of beneficiaries because, as we know, testamentary trust, it's not a legally defined term. It just means any kind of trust established on the death of a person. So a super proceeds trust is, again, not legally defined anywhere, but the phrase is industry known to refer to a testamentary trust to receive only super proceeds where the beneficiaries are limited. So, and I'm just going to pause there and check if we've got any questions. So bear with me. Okay. So, no questions yet. Send through your questions as we go if you like. And thanks, Jared, for the encouragement. Okay, so when I'm saying that the super proceeds trust is just like a testamentary trust with a narrower range of beneficiaries, what we're talking about here is limiting who can benefit. So I've got up who I think would normally be included in a typical law firm provided testamentary trust will. So the beneficiaries of a standard testamentary trust would normally include the spouse of the deceased, the minor children and the adult children of the deceased. We better put grandchildren on there as well. Where can they go here? Grandkids of the deceased. Siblings, parents, nieces, nephews, aunts, uncles, cousins, grandparents, right? Often you'd include companies and trusts of all of these other beneficiaries, and you might split the beneficiaries into different classes like primary, secondary, and tertiary, that type of thing. Now, the super proceeds trust needs to have a narrower range of beneficiaries. The whole point of using the super proceeds trust is to show the tax office that the people who received the super are only CIS Act dependents. So the tax office lets you have a look-through approach through the super proceeds trust, and if you can say that the only people who can benefit from the super proceeds trust are the CIS Act dependents, then the tax office will treat the lump sum payment of those benefits as if it went to a CIS Act dependent, even though it went to the trustee of a special testamentary trust. So that's the whole reason why you would use one of these. If we just recap back here, so if we look at these two options, paying it directly to a CIS Act dependent versus paying it to a super proceeds trust. If it goes to the CIS Act dependent directly, if they receive the super in their own name, do they get any asset protection? No. That super proceeds that they've received is exposed to their asset protection risks, so whether that's bankruptcy, creditor risks, or relationship breakdown risks. Can they stream any income that they earn from receiving the super and investing that super? No, there's no income streaming either permitted. Versus paying it into the super proceeds trust. Do you get asset protection? Yes, it's held in a trust. Usually it will be a discretionary trust. Do they get income tax streaming benefits for any income they earn from investing the super? Yes. So the reason you would go through the effort of setting up a super proceeds trust in the will is for asset protection and tax streaming, whilst achieving the exact same tax outcome on the payment of the lump sum benefits as if it had gone to those beneficiaries directly. Okay? So back to how you actually craft one of these from a beneficiary perspective. So we've got our full range of discretionary beneficiaries. The way that these work is by overlaying the definitions of CIS Act, so Superannuation Industry Supervision Act, industry dependence, and the definition of dependence in the Tax Act. So if we have a look, we've got our CIS Act dependence. Includes the spouse of the deceased, minor children, adult children of the deceased, and anyone else who's a financially dependent, or as we discussed, the legal personal representative. So only people within this red bubble here can actually receive the super. But the Tax Act definition of death benefit dependents is more narrow. So yes, these people here in the CIS Act definition can receive the super, but only the people in the Tax Act definition, so that's the Income Tax Assessment Act 97, can receive it tax-free. So the biggest issue there is children. So that's where this comes up mostly. If the children are under 18 or they're financially dependent and under 25, then they can receive the super tax-free. And if they're over 25, then they will have to pay tax on the super. So we would probably all know this. It's, you know, in Australia we say there's no death tax, but this is arguably one exception where there is some death tax. So what you have to do for your super proceeds trust is limit the beneficiaries to the Tax Act death benefit dependents. Okay, so only Tax Act death benefit dependents can be the beneficiaries of a super proceeds trust. So that's why you would normally have a testamentary trust with the full range of discretionary beneficiaries set up to receive the majority of the estate assets, but a special super proceeds trust just to receive the super proceeds. Now, the tax office does confirm that they will look through the existence of the super proceeds trust, provided that only Tax Act death benefit dependents are entitled to the capital and the income. Now, I wrote a paper on this a few years ago. The conservative position is that the income and the capital beneficiaries of the super proceeds trust must be limited to these beneficiaries. But if you want to be more aggressive, there is, I think, a pathway where you could actually have a normal discretionary trust with the full range of powers, limit the beneficiaries just to Tax Act death benefit dependents, but later on vary that deed under the variation power to add in the broader beneficiaries that you typically have as income only beneficiaries, because when this assessment is done about what was the tax consequences of paying the super lump sum to the super proceeds trust, they only look at it at the time of the payment and who the beneficiaries are. So potentially you could add back in those other beneficiaries as income beneficiaries. I think that would be quite aggressive, but if there was good reason to do that, then it might be worth pursuing. So, I was going to make one more point, and I'll just check the comments as well. Okay. So what we might do is go back to this question. So what does a super proceeds trust look like in a will? Because the question that came through from one of the financial advisors was saying, well, you've been through your module about testamentary trust and super proceeds trust, and you said we definitely need one, they make sense, that's great. But I've read heaps of wills and I've never seen an obvious super proceeds trust. So, and the question was, are they missing? Have they just not been included? Now, the chances are that you probably have, or those wills that you were looking at probably did have super proceeds trust in them, but they weren't as obvious. So there's basically two main ways that people draft these super proceeds trusts. So the first one is just like a separate super proceeds trust TDT. Okay, so you'll have like a very long document, which is the will, and it will say, I gift, the balance of the estate to this testamentary trust, and it'll set out all the terms. And then you will have another clause which says, I give any superannuation proceeds received by the legal personal representative to this other trust, which is the super proceeds trust, and these are the terms for that trust. So it's set out really clearly as, a distinct, separate trust with all of the terms set out. I don't actually do that approach in my document because you don't always know whether you will need a super proceeds trust or not. So for instance, you might prepare an estate plan for a couple who have children under 25, but they may not die, or one of the spouses may not die until the children are over 25. And if they're over 25, then you don't actually need a super proceeds trust if there's no super going in to the benefit of those kids. So, you may not actually ever need the super proceeds trust. It's good to provide for it, but it really is going to depend on the family circumstances at the date of death. Alternatively, we might be doing an estate plan where there are adult children over 25, and you might go, oh, sorry, we missed the boat. There's no point in using a super proceeds trust. But at the date of death, one of those adult children may actually be a CIS Act and Tax Act dependent because, they're financially dependent, they've got a disability, something like that. And we actually do need a super proceeds trust, but we didn't set one up in the will because it didn't look like it was needed. So the approach that I do, if we go back to this side, is an executor power. So I include a clause which gives a power to the executors to set up a super proceeds trust. So it basically says, if the legal personal representative receives superannuation proceeds and there are people who satisfy the Tax Act definition of death benefit dependent, then the executors are empowered to establish an additional trust on exactly the same terms as the testamentary trust, but the beneficiaries of that special trust are limited only to the death benefit dependents. So that's about, I don't know, 1 or 2 clauses and a couple of extra definitions in the document, rather than, a whole extra, 10 pages setting out exact terms of the trust. So you then rely on the executors at the time of death, when they're administering the estate, to decide whether to enliven a super proceeds trust. So that gives you more flexibility. I think the downside is, firstly, it's probably not obvious to the client. You really need executors and advisors to the executors knowing, being on the ball and identifying that, but it does give maximum flexibility, because if you go with option 1 and you mandate the payment of the super proceeds into the trust, but no one at the date of death is actually going to be eligible for the tax treatment, then you don't want to bother with setting up an extra super proceeds trust, or there'd be no beneficiaries actually. So either is fine. I've seen it be done both ways, but just a heads up. So if you are looking for a super proceeds trust and a will, you may need to keep an eye out for this second option, which is not going to be as obvious on its face. Now, I've also have helped a couple of lawyers who aren't sure about whether their precedent allows this. I'm happy to do reviews for any lawyers in the group who are interested in finding out if their deed does include that, or how we could incorporate that power into the deed as well. Okay, so we don't have any questions. If there are any questions afterwards, put them in the comments. If you're watching the video after the fact, put them in there. I'm happy to answer them. If you have any specific questions, feel free to get in touch as well. And as always, I will put this video in our learning modules so that you can refer back to it every time you need to. Thank you so much for watching.